Good afternoon, everyone. Bill Bronchick just joining you for Webinar Wednesday. Welcome to this platform. Thank you for joining. We will take questions toward the end, but I'll try to take a few as we go as they are relevant to the topic. Just pop your questions in the Q&A and I'll be happy to answer them for you. Today, we're going to talk about bulletproof asset protection and using family limited partnerships and LLCs to accomplish that. This is part of my bulletproof asset protection system, which many of you know I have an upcoming workshop on coming up next Saturday, a week from Saturday, April 3rd. You just check your emails about that. You will see an advertisement for the asset protection all-day workshop. And as well as you know, I have some services and products related to this, which I'll tell you about later. Asset protection is about what you know, what you don't know, and then the really scary part, what you don't know that you don't know. And that's usually when you're in front of a judge and they're telling you what you don't know that you don't know. And that's a scary place to be in business. Now, whenever I give this conversation, there's always people who say, that's really great, Bill, but I'll do it tomorrow, or I'll do it next week. I'll do it after my divorce, or I'll do it next year. I'll do it after my kids are out of the house. I'll do it after I get my new job. I'll do it when and if and whenever. And here's the problem with that thinking. Even if there's nothing to threaten you with now in terms of liability, lawsuits, litigation, etc., there is a look back period. And the look back period is a little different from state to state. It's anywhere from 3 to 6 years. It's called a fraudulent conveyance. Now you're saying, well, I would never fraudulently convey my assets, but that's not what I'm talking about. The law prevents you from doing what is called fraudulent conveyances. A fraudulent conveyance is when you transfer assets, either knowing there's a liability or within the statute of limitations, that frustrates a creditor. And that transfer is less than reasonably equivalent value, and it was to an insider. So you to a spouse, you to a kid, you to a friend, you to your own entity, et cetera, et cetera, et cetera. And the problem is most people wait until trouble comes before they do this, and it's automatically a fraudulent conveyance if you do it knowing that there is something lurking out there. They don't even have to prove the other factors. The other factors, even if there's nothing looming while you're doing it, there's still a look back period to see whether you transferred for less than reasonably equivalent value to an insider. And that transfer frustrated a creditor. So the bottom line is the point I'm trying to make is that you want to do this now while things are fine, while there's nothing out there looming. And then if a lawsuit comes and you can beat that statute of limitations, or at least do the transfer while nothing is pending, you have much better chances of succeeding in protecting your assets. And then there are people who think, well, it just won't happen to me. And they think they're too smart or too nice to people. They treat their tenants and their employees and their business customers well. And they think that will prevent them from being sued. And that's just naivete. There's an old expression, no good deed goes unpunished. And I'm sure many of you out there know this, that you've helped out a friend, a family member, a customer, a tenant, an employee, only to be turned around and stabbed in the back and with no appreciation for what you did. And that's why we have to protect ourselves. So think it won't happen to me and put your head in the sand like this ostrich, that's just naivete. I mean, it's just not a matter of if you will get sued, it's just a matter of when. And if you're an employer, if you have employees, or you're a landlord and you have tenants, they are particularly easy targets. Lawyers love suing landlords and employers. Why do you think that is? Think about that. Why do lawyers love suing landlords and employers? Well, the answer I usually get is, well, because landlords have assets and so do employers. They have a business to go after. And that's true to some extent. But the real reason, I'll tell you, is because the jury pool is not going to be made up of people of your peers. You're not going to get a jury full of other landlords and employers. You're going to get a jury full of tenants and employees. And everybody hates their boss and everybody hates their landlord. So when they get to court, it's payback time. So you do not want to be in court as a landlord or employer. The odds are not in your favor, even if you did everything right. So my bulletproof asset protection system has 4 parts to it. We're going to go over one of them today, but I wanted to give you the overall context in which what I'll be talking about fits. So these are the 4 steps. You want to take out a pen and write them down. Number 1 is appear broke. Now, that's not just physically appearing broke, like don't drive a flashy car, don't go pick up your rents in the Benz, don't, park the Jaguar out back to where your employees can't see it or your tenants. But I'm talking about more so what you look like on paper. There was a time in the 80s when Trump was supposedly broke. There was a newspaper reporter who caught up to him and caught him in a bad moment and said, "Hey, Mr. Trump, how's things going with your business?" And he pointed to a guy pushing a shopping cart and he says, "You see that guy over there? He's worth about 10 million more than me." So I know, on paper, Trump looked like he was broke, but he was still living high on the hog in limousines and private jets and, fancy residences all over the world. I mean, it just looked like on paper he was negative. And that's the idea. You want to look like on paper you're not worth suing. So one of the things we do is we use things like land trusts to mask your ownership of assets and so forth. And we want to make it look like your assets are leveraged. Number 2 in the 4 steps is to create a liability shield between you and the assets that create liabilities. So for example, if you own a business in your name, then your employees are going to sue the business owner, i.e. you. If you own your business in a corporation or LLC, they're going to sue that entity. They could try to sue you too, but unless you personally committed a wrongdoing, if the allegation is you, for example, allowed other employees to create a hostile work environment for sexual harassment, as long as you didn't do the harassment, you're not liable. Just the company would be liable. But if the company were just owned by you as a sole proprietor, then you would be liable. Or for example, if you have an automobile you use in your business, you'd want the company to own it, not you per se. So if one of your employees gets into an accident, you as the owner would be normally liable. But if it's the company, then the company would be liable. So we need that liability shield. Number 3, we want to segregate assets for a number of reasons. Number 1, we want to divide up assets by risk and by value. For example, owning a rental property would be a high-risk asset. Owning a car in your business is a high-risk asset. Owning a business is a high-risk asset. So we want to put those into separate baskets, not just separate from each other by value, but separate by the assessment of risk for each asset. So for example, would you want to have an LLC that owns 6 rental properties and put all of your stocks in that company? Of course not, because a lawsuit from the high risk asset will poison the low risk asset. So we want to break them up by risk and by amount. So even if there is a lawsuit in your business, it won't affect your real estate and vice versa. Okay. And number 4, finally, becoming legally judgment proof. Becoming judgment proof. And that's what we're going to talk about today, using family limited partnerships and LLCs to do that. So if someone does get, through the appear broke, create a liability shield, gets a judgment against you and tries to go after your assets, what are they going to legally be able to get? Okay. So there are places in the law that a debtor, which would be you, the defendant, would be protected from the claims of a creditor, i.e. a plaintiff. A perfect example would be the OJ debacle, right? OJ got a $35 million judgment against him from the family of the ex-wife he killed. Oh, allegedly killed. I'm sorry, he was acquitted. But in civil court, they proved it, because you don't have to prove beyond a reasonable doubt in civil court. They got a judgment against him for wrongful death, and it was about $35 million, and they've collected very little. Why? It's not that OJ doesn't have anything. He does. It's just that the law protects what he has. So for example, he has a residence in Florida. Residences in Florida are protected from creditors under their homestead laws, 100%. You can't take A garnishment on someone's salary in the state of Florida. So if he has a salary from his business, can't take it. His pension from the NFL, that's protected under federal law from creditors. So those are not good examples of a person for using ethical principles, but you get the point I'm making, is that there are certain things in the law that protect even the worst people. They may have hopefully protect you who are watching, the good people. Okay, so important. Again, I'm going to urge you to, if you like what you hear, if you see what I'm saying, if this grabs you, take action. Take action on it as soon as you can, and don't wait until something bad happens, because it'll be too late. All right, so becoming legally judgment proof, we start with the entity known as a family limited partnership, family, or FLP, we'll call it for short. Now, what is a family limited partnership? An FLP is a limited partnership between family members, essentially, but has certain characteristics in its paperwork that gives you protection. Certain characteristics under state law that give you protection. A family limited partnership is owned by partners. It files with the state a certificate of limited partnership, just like a corporation files an articles of incorporation, or an LLC files an articles of organization or certificate of organization. So there is a filing with the state. This is different than a general partnership, which is between partners as well, but does not file a certificate with the state. Okay. So one thing I wanted to make sure that we're very clear on: an FLP, limited partnership, is not the same as an LLP, a limited liability partnership, LLP. What is an LLP, and what is the difference between that and an FLP? An LLP is used by professionals, architects, lawyers, accountants, doctors, dentists, etc., to limit the liability for malpractice of your partners. It doesn't protect you from your own malpractice, but of course you would have liability insurance for that, E&O insurance, errors and omission. The problem with law firms and architectural firms and dental firms and all those things, for years they were general partnerships. And the problem with general partnerships is you're liable not only for what you do, but for every single one of your partners does. So perfect example of that in play was, there was a law firm in the 80s called Finley Cumble. Finley Cumble wanted to become one of the largest law firms in the world. So they became aggressive in recruiting young associates from other firms. And typically at that time, it was 6 to 8 years before you became a junior partner in a law firm like that. They would go to young associates who were 3 and 4 years at other firms and say, hey, we'll make you a junior partner now. Just come over to us. And in part of that transaction was the young associates signing a partnership agreement to be bound by the partnership agreement of the firm. Well, they overexpanded after the crash of the 80s. They crashed too, and they had to downsize significantly, and a lot of people bailed out. And what happened was the young associates who became partners were all liable for everything: the office leases, the vendors, all the creditors that came after them. And these poor young associates didn't, realize, I mean, they should know better, they're lawyers, but they ended up filing bankruptcy, and that's a shame. So what happened is the state started creating this entity called an LLP, where you can register your general partnership with the state, fill out a form, and you're not liable for things that your partners do. You're only liable for what you do, but you carry insurance for that. You carry liability insurance for that. So that's not what we're using, LLP. And that's not to be confused with an LLC, limited liability company, which we'll talk about in a bit. Okay, so this is an FLP. Under state law, there's no such thing as a family limited partnership. A family limited partnership came out of a provision of the tax code, which talked about limited partnerships between family members, and was plugging up a loophole where people had to shift income from themselves to their kids who were limited partners. We're not using it for that purpose. We're using it for protection. We're using it for estate planning, as you'll see. So limited partnerships are owned by partners. We have 2 types of partners: general partners and limited partners. General partners run the show. meaning general partners are in charge of running the partnership business. They decide when and how it does business, and how and when and if distributions are made to all the partners of annual income. Is it possible the partnership can make money and not distribute income to its partners? Yeah, if you've ever been a partner in a partnership like this, you know that's possible. So general partners run the show. On the other hand, limited partners shut up and put up the dough. So before LLCs came along, limited partnerships were very common for development projects. A general contractor or his corporation would be the general partner running the show and making all the decisions. And then the limited partners were investors. So as a shopping center or something like that, or an apartment building, the investors would be limited partners. So limited partners put up money, but they have no liability. They also have no say-so in the company other than to vote, if the limited partnership agreement allows, to fire the general partner and get a new one if they don't like them. Sometimes the agreement says you can't do that, and you're stuck with that general partner. General partners run the show, usually don't put up much of the dough, but they make all the decisions regarding the company. Here's another important thing. I said limited partners have no liability besides what they put up. They can't be sued beyond their investment. General partners can, though. A general partner can. That's why I mentioned a general partner might be a corporation, not an individual. Or you might use a limited partnership in layers, as we'll discover as we go. These are great for asset protection. They've been around since the 1920s in most states. And the way it works is something like this. We have a corporation, or maybe even an LLC as a general partner, owning 1% of the limited partnership. And then let's say husband and wife own the other 99%. Can it be 49.5, so they're equal? Yes. Can it be 30%, 69%, husband and wife? Yes. Which one is better? It depends. Yeah, I'm not going to give you an exact answer. I'll explain to you the concepts and you'll get an idea of which one is better. Assets in a family limited partnership are essentially judgment proof. Judgment proof. What does that mean? What that means is that a creditor has an extremely difficult time getting to your assets that are held in a family limited partnership. And let me give you an example so you get some numbers and get a flavor of how this works. Let's say we had a limited partnership, an FLP, with $1 million in assets, and the general partner was a corporation. Now, could that corporation be owned by this same husband and wife, or an LLC owned by this same husband and wife? The answer is yes. So the husband and wife could play two roles, each owning a 49.5% limited partnership interest from which they get distributions. But who controls those distributions? Who makes all the decisions? The corporation. But who controls the corporation? The husband and wife. They're just, one's the left hand and one's the right hand. One's a general partner controlled by them. One is a limited partner. They are individually. Okay. So let's say there's $1 million in assets and there's $100,000 in annual income in the business of this family limited partnership. So, by the way, just picking your brains here for those of you who are investment experts. If you've got $1 million in assets and you have $100,000 in annual income, what's your annual return on capital? Let's see if someone could pop it in there in the chat. You got it. Charlene got it first. 10%. 10%. That's right. You earn 100,000 on $1 million. That's 10%. 100,000 goes into $1 million 10 times, right? So it's 10%. And so if there was 100,000 in income and the general partner owned 1%, it would get a 1% of 100,000 or $1,000 in income that year. And then the limited partners would get at each 49,500 of that income. Now, they don't actually get the income per se, but that amount of income is attributable to them. What do I mean by that? Well, a family limited partnership, like all partnerships, are pass-through entities. They file an IRS form 1065, which is a partnership return of income and expenses. So an LLP, an FLP, an LLC, in some cases, and a general partnership all file the same general partnership or partnership return. Okay, 1065. So the company doesn't pay any corporate level tax like a C Corp does. Everything passes through like on an S Corp. Each partner gets a Form K1, which says to the IRS and to them, here's your share of reportable income, or in case of a loss, your share of loss for the year. Okay. In this case, if there was 100,000 in net annual income, right, and the general partner owns 1%, he'd be attributable to 1,000. He'd get a K1 for 1,000, and each limited partner would get a K1 for 49.5. Now, this is taxable income whether or not the FLP distributes the money to the partners or holds on to it for future investment and activity. And by the way, again, whose decision is it to distribute or not distribute? That's right, the general partner. And who controls the back door of the general partner? The limited partners, in this case, husband and wife. So a creditor comes along, gets a judgment, let's say against husband, and the creditor is going to try to attach husband's income. So let's say income is being distributed to the husband each year in the amount of $49,500. Creditor comes along, says, I've got a judgment for $250,000, so I'm going to get 5 years of that income until the judgment is satisfied, more or less. At that point, the creditor would apply to the court for what's called a charging order. What is a charging order? It's an order. It's a decision or demand or order signed by the court, which says do something or don't do something. That's what a court order is. So the court signs a charging order directing the general partner to distribute to the creditor what it was distributing to the husband, the 49.5 each year. Okay. That's not good for husband, right? Well, what if the general partner in its infinite wisdom decided, you know what? I don't think we're going to distribute any more income this year because it's better to hold on to this money and reinvest it. And then at that point, how much does husband get? The husband gets nothing. So if the husband gets nothing, what does the creditor get? The creditor gets nothing too. And is this legal? Absolutely. It is absolutely legal. Okay. The corporation, which is the general partner, even though it's controlled by husband, it's not just controlled by husband, it's controlled by husband and wife. And it requires unanimous consent for all distributions. And wife says no, and husband says yes. There you go. There's no distribution. So what does the creditor get? Jack squat. Year 2, same thing happens. Year 3, same thing happens. What is the creditor getting? Nothing. Well, the husband's not getting it either, but it's still, in the company which the husband and his spouse control and have access to in many different ways and shapes and forms. Okay. Here's another thing. Let's say this happened and the creditor was entitled to the charging order and got the charging order and served it on the general partner, and then the general partner stopped distributing income to the husband. Would the husband still be liable for the income tax on the undistributed income? Because remember, I said earlier, income, whether distributed or not in a limited partnership, is taxable to the partner whether he receives it or not. Well, according to a ruling during the Carter administration, in this scenario, the creditor would not be entitled to the income, but would get a K1 for his share of the phantom income, the undistributed phantom income. Now, let's just back up a second and see how it goes here. Someone sues you, gets a judgment against you, beats you in court, gets a charging order against your $1 million asset. Can't get to the assets, but they can get to the income. The income is shut off by the general partner, which your spouse and you control. No income to you, no income to the creditor. Creditor gets a tax bill for your undistributed income. That's pretty good. I like that. Now, lawyers aren't stupid, by the way. Plaintiff lawyers know this. They're not going to try a charging order if they know they're going to get a tax bill for their client. They'll get sued for malpractice. Okay. What about charging order protections for LLCs? Now, some of you may or may not know this, but LLCs in many states do have charging order protection the same. So if this was an LLC with members, then the manager would shut off the cash flow. Or if you're not manager managed, you're member managed, the other members could decide, well, no, we don't want to distribute income. And if it requires unanimous consent to distribute income, it doesn't happen. Okay. So do LLCs provide the same protections as FLPs? And the answer is, it depends on which state you're in. Okay. So in these states, the law says that the only and sole remedy of a creditor of an LLC membership is to get a charging order. Sole remedy. And that's Alabama, Alaska, Arizona, Connecticut, Delaware, Maine, Mississippi, North Carolina, Texas, Wyoming. What if you live in a state other than these I have listed here? Can you form an entity in that state and then register it in your state? The answer is yes, you can. What about the states, if you already have an LLC in a state other than the ones I've listed here? Are you in trouble? Not necessarily. What are the other remedies, by the way, if they're not limited to a charging order? Well, a creditor could, in theory, ask the court, and it's not that they get it automatically, it's the court's discretion, to foreclose on the membership interest. Now, think about that logistically. You own let's say a 49.5% membership interest in an LLC that owns some assets, and your spouse and maybe your kids are also members. A creditor applies for a charging order, the income is shut off. Creditor gets nothing. So the creditor says, oh, I got an idea. We'll foreclose the interest and put it up for sale. Really? First of all, how do you value a minority interest in a company with no voting rights? Because whoever buys this thing at the foreclosure sale doesn't get the right to demand income no more than the creditor would. So who's going to pay dollar for dollar, $490,500 worth of husband's share at a sale? No, they'd pay maybe 10 cents on the dollar. Well, if that's the case, if 10 cents on the dollar is the high bid, go get your friend or your uncle to go bid it and buy it back from them. It's like settling the case for 10 cents on the dollar. So even in states that allow other remedies, I don't think it's that big of a deal. Now, single member LLCs, that is an LLC that has one owner. You individually are the sole owner, okay? What about those? Well, here's the challenge. Several courts have ruled that single member LLCs are not protected. The first one was in Colorado in a federal bankruptcy case called In Re Ashley Albright. You can look it up, Ashley Albright. It was about 15 years ago. And it makes sense if you have a double member partnership or double member LLC, that it shouldn't be fair that a creditor can come and, blow up the entity and screw all the other partners who are not creditors, right? By selling off the assets at discounted prices. So that's the reason for the charging order limitation. But with single member entity, if you're the only owner and a creditor wants to say to the judge, well, look, who are we hurting here? Let's bust up the entity and get all the assets. And the court ruled in that case that the creditor could. And several other cases, there's one in Florida, there was one in Maryland, said the same thing. It's not universally the law, but as a result of this, some states have enacted legislation specifically protecting single member LLCs, which overrides the court decisions. So you can form an LLC in one of those states and register it in your home state if you're not in those states. And those states are Alaska, South Dakota, Nevada, not surprisingly, Delaware, not surprisingly, and Wyoming, the first state that had LLCs. They probably have the strictest pro-debtor statute that exists in LLCs in the country. And not only that, but it's a relatively cheap state. It's only about $100 to file and $50 or $25 a year. So Wyoming's an excellent place to form a single member LLC if you are the sole member individually the sole member. Okay, if you formed one, let's say single member in Colorado, it's probably better if you're going to hold assets in that to be a double member LLC or maybe redomesticate it in Wyoming. You can actually do that. You can actually form an entity in Wyoming, take your New York or New Jersey entity and merge them together so they become officially a Wyoming, Delaware, Nevada, or Alaska, or South Dakota entity. So putting it all together, I talked about earlier the 4 steps. One I said was appearing broke. So we usually take, let's say, a bunch of real estate, put them in separate land trusts. That gives you a layer of anonymity. The beneficiaries of the land trust could be one or more LLCs, and then layer it down to a family limited partnership. So the first layer is anonymity, the land trust. The second layer is liability protection, the LLCs, and the LLCs are all owned by a family limited partnership where we have a corporate general partner and husband and wife as limited partners. Okay. By the way, for a single person, someone asked me, can a single person do this? And the answer is yes. Yes, it does. So if you're a single person, you could do it where you're the sole member and, the sole limited partner, and your corporation you own or LLC you own, if it has an S Corp election, can be the general partner. Or you could form a master LLC, a family LLC. That's another type of entity. It's really nothing special about with the state, an LLC is an LLC, but we're calling it family LLC as opposed to FLP, family limited partnership. So if you form in one of those states or you live in one of those states that have charging order protection as a sole remedy, you could have an LLC be the master entity and have sub LLCs. And then you'll be the members and managers as husband and wife. Now for estate planning, let's take it one step further. If you are doing estate planning, what a lot of people do and a lot of lawyers recommend is taking all your real estate and assets and putting it in a living trust to avoid probate. Is that correct? Well, if your only goal was to avoid probate, that is correct. However, a living trust offers no liability protection. So if your living trust, which owns all your real estate, was sued, it would lose all its assets, all its real estate. So that's not the best way to do it, I think. I like using the land trust for anonymity, but even if you don't use those, you should at least use a couple of LLCs and break up the basket, as I talked about earlier. And then the LLCs are owned by a master entity, a parent entity. Think of General Motors, parent entity, Buick, Cadillac, Chevy, sub-entities or child entities or subsidiaries. So the family limited partnership is like General Motors, and these 3 LLCs are like Buick, Chevy, Cadillac. I'd say Pontiac, I almost said, but I don't think Pontiac's being made anymore. I think they're down to those 3. Maybe GMC is the last one they have left. And then the limited partnership would be owned 99% as limited partner, your living trust, your estate planning living trust. And your corporation would be the general partner, and that could be into the living trust, but I don't think it has any real value. It only owns 1%. It's just there for control because you can always replace it. Likewise, if you had an LLC, you could do the same thing. You can have the master family LLC with a living trust, a joint living trust, or if you have separate living trusts, your 2 living trusts as members, and then you individually and your spouse would be managers. If you're a single person, can you just be a sole manager and have your living trust as the sole member? If you form it in one of those states, the 5 states that I mentioned earlier, I would recommend that. Now, setting this up is like lawyer repellent, just spray it on, deep woods lawyer repellent, and the lawyers go away. It's very, very effective. So let me answer some questions here. Judy asks, are family limited partnerships used with IRAs or solo 401ks of the family members? Well, you can certainly have yourself as general partner or your corporation as general partner and your IRA or solo K as limited partner. That's fine. Most people do that with an LLC where they're members, but there's nothing wrong with doing that. That could certainly be done that way. Now that one's a more detailed. Someone was asking about keeping assets from the state or for Medicaid, but I don't want to answer. That's kind of off on a tangent. Okay, so someone asked, is your spouse in an LLC considered another member for the purposes of asset protection? That's a great question, Brian. That's an excellent question. And the answer is we don't know yet. There's not been a case. Well, put it this way. For tax purposes, husband and wife could be one person, or husband and wife can be a filing partnership. Okay. In a limited partnership, it's pretty clear because limited partnerships need two members. So husband and wife are clearly two separate people. In an LLC, if you choose to be taxed as one person, but you are husband and wife, two separate human beings, do you get the benefit of charging order protection? Or is the court going to go, well, husband, wife, same party, so we're going to allow them to bust this LLC just like a single member LLC? And the question has not been answered by any court yet. My gut feeling, Brian, is no, they wouldn't do that because two human beings are two human beings, okay? It is what it is. And it doesn't mean just because they're married, they agree on everything anyway. So I think that's fine. If you wanted to be absolutely so sure in your husband and wife, could you form in Wyoming or Delaware or Nevada? Yeah, that would give you an extra, nail in the coffin for potential creditors. Sheila asked, do we need to request a copy of the slides? Sheila, all you got to do is email me and ask, except one thing I ask of you. Give me at least a $25 donation to a reputable charity of your choice, a reputable charity of your choice. Send me the receipt, and I would be more than happy to send you a copy of my PowerPoint slides. How's that? So Caroline says, if an FLP needs two members, then a single person cannot have one. You missed the slide earlier where I had a corporation as a general partner, which you own, and you individually as another partner. Can you be a partner with your corporation in a limited partnership? Absolutely, you can. The law looks at a corporation as a filing entity, a separate individual from you. Now, in an LLC, where I was talking about husband and wife, they could file as a partnership or file as one person. Does that erode the double member protection? My gut feeling is it does not. But if you wanted to be 110% sure and sleep at night better, you might still form your entity in a state like Nevada or Delaware or Wyoming. Okay, good questions, by the way, everybody. Okay, as we wait for more questions to pile in, I've got some other opportunities. And again, remember, timing is everything. You don't want to wait until something goes wrong because that is not going to be effective for you. I have, in addition to further education on this, so we have 3 ways you can take action on this, basically. Number 1, I have a workshop I mentioned earlier, April 3rd, Saturday. If you didn't get the email for whatever reason, you happened to get the email for this webinar, I don't know how that's possible, but if you got one and didn't get the other, do email me and I'll give you the link to the workshop registration page. It's $197 for the workshop. It's not expensive and it's all day. So you're going to get lots of questions answered. I also do this stuff as a lawyer. So you can email me if that's what you're interested in, or you can get my Bulletproof Asset Protection Home Study Kit, which is only $997 tax deductible and will save you a lot of money because, I would charge you thousands to do this. Whereas my kit will give you everything you need to file, do the tax forms, take deductions, your operating agreements, your resolutions, your corporate minutes, everything you need, land trusts, FLPs, LLCs, tax saving strategies, estate planning strategies, everything I've talked about times 100 you will find in this program. And if you use the code webinar at legalwiz.com, you will get 50% off today, just today. So use the code webinar at legalwiz.com. Just click on store and you'll see the Bulletproof Asset Protection package there. Okay, so we have some questions coming in here. Luke asks, how would a series LLC fit in that diagram? That's a great question, Luke. So instead of using master and sub LLC, you'd use series LLC, just one entity as your master entity, and then your sub entities are your series. Same as if you had separate LLCs and master LLC. Daleen also asked that as well. Yeah, same thing. So series LLCs just simplifies the equation a little more. In my example there was someone who had like 8 or 10 properties, and I had 3 LLCs to break them up. If you had 15, 20, 25, 30, I mean, if you had a lot of properties, series LLC is definitely something to look at. Remember, if you're not in a state which doesn't have series LLCs, you have to form in another state like Delaware or Wyoming, or Nevada that has series LLCs, or Texas. And there's about 22 states that have series LLCs now. Oklahoma, Nebraska, what am I thinking? Where am I missing of? Iowa has them. Indiana has them. A number of states. Utah has them. Unfortunately, Colorado, where I am, doesn't have them yet, but they're toying around with the bill. Okay. Are series LLCs easier to manage than multiple LLCs? You know, Brian, when you get to the point of having, 4 or 5 sub LLCs, I think a series LLC is a little easier to deal with, because you need fewer bank accounts. Kim asks, so properties in an LLC or FLP go through probate. Yes, your membership interest or your partnership interest. But if it's owned by a living trust, then the properties the LLC or FLP owns don't go through probate. That is correct, because the properties are owned by the FLP or LLC. The LLC at the bottom, or master FLP, is owned by your living trust. So what gets passed to your heirs is the keys to the company, the keys to the master company. And then from that, everything flows downward from those. Good question. Okay. Tammy writes, I have a series of LLCs for rentals. If I want to get certified as a notary as a side hustle, can I put my notary business in a series in my same series LLC? I guess so. I don't see any reason why not, Tammy. It's just that as a side hustle, I'm not sure being a remote notary is worth the effort. Remote notaries get what, 50 to 75, $100 tops for showing up at your house to notarize something. If you want to make more money, you could be a closer. With everybody home with COVID, banks and title companies are going crazy looking for presenters, people to present loan packages. So the lender emails you a package, you go to someone's house, you get them all their signatures on the note, the mortgage, and all the other related documents, you ship it back, and they pay you, $175 to $200. That's a decent side gig. And yes, you can use, Tammy, one of the series of the series LLCs to do that business. Luke asks, would you recommend moving my truck that I use for business into my series LLC? And if so, would I put this in a series? The answer is yes. And yes, if you solely use that for business and nothing else, and not personal use, and your insurance is not significantly more expensive being a commercial policy. Daleen asks, is there a difference between a living trust and an irrevocable trust with regard to protection from creditors? The answer is yes, but I think you're asking it wrong. A living trust is created while you're living. So a living trust can be revocable or irrevocable. Okay. do irrevocable trusts in general give you better protection from creditors than revocable trusts? The answer is sometimes. If you set up an irrevocable living trust for yourself, whatever you have control over, so do your creditors. So if you can have, if you're the trustee and beneficiary and have full control over those assets, can the creditor get to it too? Probably. Now, there are some states that have what are called irrevocable domestic asset protection trusts. Alaska is well known for that. They were one of the first states to have it. Nevada has it. Rhode Island has it. So there's only a handful of states that have it, but being outside and having assets outside of those states, I don't think it works. Courts are not going to honor those things in other states, is my feeling. Can you form one in Nevada and then live in Colorado? In theory you can, but all the assets would have to be held in Nevada for this to potentially work, and you'd have to have some sort of residency in Nevada for that to work. Good questions. Okay. We have a couple more chat questions here. Shirlene was ordering and didn't see where to put in the code. Email me if you're having a problem with that, Shirlene. I don't think that should be a problem. If you're ordering the asset protection package, there should be a place when you check out to put in the code. So if you're having a problem with that or any other issue with my website, just email me directly. Be happy to help you out with that. So again, go to LegalWiz.com, click on store. You'll see that and other packages, and use the code webinar today for 50% off this or any other package on LegalWiz.com. I have 16 of them on real estate, asset protection, LLCs, hard money lending, creative real estate financing, subject to lease options, wraps, everything in real estate under the sun, you'll find at LegalWiz.com. So thank you everyone for joining me today. Thank you for sharing your questions, and I really appreciate your attending. We'll see you on the next Wednesday webinar. Have a great day.